Okay, hello dear students. Welcome to this video lecture series on behalf of Project Sathi. Today we are going to discuss, today we are going to continue our discussion on general exceptions. I am Dr. Animesh and today we will continue with our discussion on general exception. This is the fourth lecture of second module and we'll discuss several exceptions today, which are again very interesting. This is going to be a long lecture, so have some water and let's sit tight and start our journey of knowledge. Okay, so first exception that we are going to discuss here today is necessity. Now, there is a maxim called sive necessitas non habet legum, means necessity knows no law, or we can also say of what is necessary is legal. Necessary simply means uh, that when you do an act in order to avoid a greater harm, that is called necessity. Means you have taken the risk of a harm in order to avoid some more harm from happening. It was necessity to do that harm. Like you say, many a times, most simple example, you can see that if a snake bites in part of an area, like it bites on the hand, so sometimes we amputate the hand. Sometimes gangrene happens in one of the area body parts, and the doctors, they what they do, the surgeon, they'll amputate that part of the body. Now this is very problematic, very dangerous, but still, why do we do that? So that the rest of the body can be saved. So you will say that cutting of leg, cutting of hand was necessary. So because why it is necessary? Because if you would not have done that, the harm that would have been caused will be far greater. So if you have taken the risk or if you have caused smaller harm in order to prevent a greater harm from happening, that is what we call necessity. So this is very interesting. Greater harm is about to happen and you have taken the risk of smaller harm. That is what we call necessity. And that we do all time. We do some type of cost benefit analysis in the sense that we often, more often than not, we uh, do the lesser harm, like kalvi dawai pina. Kalvi dawai pina is very difficult, but obviously our health is more important. So whatever is more important, we do a cost benefit analysis. So in the criminal actions also the similar rule applies. Like I'll give you an example. See, in criminal law, the Bharatiya Nyaya Sanhita and before IPC also gave this example in this provision that suppose there's a person who is a captain of a ship. Captain of a ship, actually he sees because of no fault of his own, he finds himself in a position that he will have to move the ship. He can move the ship either right or left because there is, let's say, an iceberg in front of him. तो iceberg है तो क्या करेंगे, लेफ्ट लेंगे राइट लेंगे. So in right he sees there is a small boat and there are 50 people on that boat. And obviously if he will take right, he'll have to hit that boat and that boat will be all the people who are there in that boat will drown. And similarly he sees that there is a boat having few people, 5 people, 6 people in on the left. And if he takes left, all those 5, 6 people will die. So what do you think the ship captain will do? And I believe all of you agree with me that the captain will turn left because there is the risk of lesser harm. 6 people will die in this approach and 50 people die in that approach. So sometimes you got to take the risk of smaller harm in order to prevent the greater harm from happening. N number of laws can happen. Let's see, suppose in a particular city, suppose a particular house catches fire. Now, house catches fire, and it is very much impossible for the people to douse that fire or get control over that fire. Fire brigade is not there, water is not there, and there is a risk that the fire will spread across all the colony and everything will be burnt. So what they do, they have a, let's say they have a JCB on hand, so they break the, say, destroy the house on either side of the house in which there is fire. जिस घर में आग लगी है, they destroy the houses in right and left of that house so that the fire will be contained, it will not spread. So the question is that the person who destroyed these two houses, whether he has committed any criminal act. Obviously, destroying someone's property is a crime, but he will not be held liable because he took that risk in order to prevent not simply other harm but greater harm. He took the risk of greater harm. He took the risk of lesser harm in order to prevent the greater harm from happening. The whole locality would have burned if these two houses would not have been demolished, and to stop the domino effect. So that is something that we considered as necessity in legal terminology. So what is necessary is legal. Many a times there are a number of examples can be taken in this necessity. Sometimes obviously in medical field that is often the case that we have to sometimes take out the organ of a person, amputate the hands, legs, take out the eyes of the person, whatever surgery they have to do in order to prevent the greater harm of death. A number of things they do. Okay, so but the act should be done without criminal intent. If your intent was criminal, in that case, it will not be considered as necessity. Like I'll give you an example. Now, obviously, most of the examples I take is from movies. Let's say the police they catch terrorists. You know, several terrorists are caught by police. Now, one person who is a vigilante or a police officer for that matter, he kills those terrorists so that those terrorists will not cause any more pain to society. In the sense, there is the apprehension that the supporters of those terrorists might hijack a plane or do some evil act so that no more people will die or nobody else will feel um, will not have any discomfort. So these terrorists were caught, they surrendered, they were caught by the police, and the police or army personnel killed them in cold blood. Now, the question is whether what they did is justified by law. Now, they can argue that what we did was necessary. Necessary because if we arrested them, we would have taken them to the court, they would have been sent to jail, and there would have been a long trial. And those who belong to this terrorist organization would have created more trouble for us. They would have attacked us, they would have used the hostage technique, a number of things, a number of possibilities, and real possibilities are there. So why to keep these 5, 6 terrorists alive and risk the lives of hundreds of individuals? Now the answer is fine. By your abstract sense of justice, this idea is correct. एक बार लगता है कि हाँ, ये बात तो सही है. ये 5 टेररिस्ट हैं, अब इनके इसके और टेररिस्ट ऑर्गेनाइजेशन वाले पता नहीं कितने कितने लोग मारेंगे. मसूद अजहर को हम लोगों ने पकड़ करके मार दिया होता तो शायद वो प्लेन हाईजैक जो कंधार में हुआ वो नहीं हुआ होता. But we kept him in custody. That is why this particular problem was faced by us. But very simple. The police officer who actually kills those terrorists will have the criminal intent. Obviously, you want those terrorists dead, right? And if you have the criminal intent, the defense of necessity cannot be taken. The defense of necessity cannot be taken. Okay, because you cannot do an act with a criminal intent. Why intent is very material, I'll give you another example. Story time. So see, obviously I gave you an example. Let's simplify it. Suppose you are driving a car and your brake is not working. Okay, and you see one person on this side of the road and 5 persons on this side of the road, and you will have to go on in the either side of the road, and your brake is not working. You know, if I'll turn right, one person will die. If I'll turn left, 5 person will die. So obviously, what you will do, you will turn right, you'll hit that one person in order to save those 5%. Let me give you another example in contrast. And this was a very famous lecture justice lecture is there. I taking that this example from him, Michael Sandler said this lecture is there. So on the other hand, suppose there is a surgeon, there is a doctor who has five patients who are terminally ill. They are in immediate need of transplant. Transplant in the sense somebody needs heart, somebody needs kidney, somebody needs liver, and everyone needs some organ on the other. While he has one healthy patient who has just come because of a toothache or something, and he is such a healthy person that if you will take both his kidneys, his liver, his heart, and some other organ of this person, you can save the life of those five people, but obviously this person will die. So what we are expected to do? Now nobody will say that let's kill this one healthy person, take these healthy person's organs, give those five people transplant so that they can live. Will you say that? I don't believe that you will say that. You'll say, why to kill this innocent person? This person is just having a toothache. You will kill him, you will take that person's organ and you will save the life of five others. This is not legal. You will say that. And obviously, many of us will say that. And the difference between that car driver and that doctor is that the car driver has no criminal intent, in the sense his intention is not to kill one or not to kill the five. He's just driving and he had to make that choice. And he's not on the driving seat. He is just taking a decision, smaller harm for greater harm. He's not doing any act intentionally. But this doctor is will if he kills that healthy person, he makes a choice. He is having criminal intent. So having criminal intent will take away this exception of necessity. If you are doing something with criminal intent, that means it is not necessity. Similarly, just like the example of self-preservation, suppose I steal a piece of bread to feed my family. Now I am stealing the bread. Now this is what we call criminal intent. I am taking the bread intentionally, although it is to feed my family who are dying of starvation. So one might think this is necessity, very important. But whether that is necessity, answer is no. That does not qualify as necessity. That is a crime. If a person steals a loaf of bread to feed his family, he cannot take the defense of necessity. Although obviously moral construct is there, the logic is there, but necessity involves that there should be no criminal intent. There must be a greater harm or lesser harm. If you have done something intentionally, in that case, your liability will be there. And intentionally means you want something to happen. If it has to happen, then it is different thing. But if you want something to happen, that is called criminal intent. And when you are stealing a bread or doctor kills that healthy patient, it means that he wants that thing to happen. Okay. So suppose I give an example of the train driver. Suppose you are a loco pilot of a train and you see someone right in front of you on track. What you're supposed to do? You're supposed to run over. You are supposed to hit, because you cannot apply emergency brakes or anything. Because even if you apply emergency brake, the train will still hit that person. Or if suppose there is a mechanism of putting immediate stop in the train, everybody who is sitting in the train will fall and will hurt themselves. Greater harm or lesser harm. You do not have to have criminal intent. You do not want that person who is on the track to be killed, but you do not have an option. So criminal intent is something that will take away this defense of necessity. There is a that very famous case of cannibalism, Dudley and Stephens. In what happened, there is a shipwreck. शिपरेक के बाद क्या हुआ बच्चों, एक छोटी सी बोट में 5 लोग थे समुंदर में. Obviously there was no food to eat and there was no water to drink. So those 4 of them, and they killed the youngest member, a 16-year-old teenage boy. They killed him and they survived on his flesh and blood for a few days, and then they reached the coast. वो समंदर तट पे पहुंचे और 5 लोग थे स्टार्टिंग में, उनमें से 4 लोगों ने एक व्यक्ति को मारा और उसके फ्लैश और ब्लड पे सरवाइव किया. They ate the flesh and they drank the blood and they reached the coast. Now the question is whether it was necessity. You might ask, sir, obviously they would have died. All 5 of them would have died. If they would not have killed one and ate, all of 5 would have died. So the answer is it is not necessity, because self-preservation is no necessity, and they when they killed that one person to drink his blood and eat his flesh, that will be considered as having criminal intent, and if you have criminal intent, your liability will be there. Okay. Then obviously the reasonability of risk. Now, generally it should be the case that in order to prevent a greater harm, lesser risk should be taken, not the other way around. कि छोटा सा हार्म हो रहा है और हम बड़ा सा रिस्क ले लें. समझ पा रहे हैं आप लोग मेरी बात? जैसे कि किसी आपने कहीं पे देखा कि एलपीजी लीक कर रही है, और आपने जैसे सुना कि एलपीजी लीक कर रही है, आपने पूरा सिटी इवैक्यूएट करा दिया. So now obviously the risk you have taken is disproportionate to the harm that was supposed to take place. रिस्क छोटा सा, हार्म जो है वो छोटा सा हो और रिस्क आप उसके लिए बहुत बड़ा ले लें, that is something is that is not allowed. So necessity is only applies when there is a greater harm or risk of greater harm. In order to prevent that, you have done the lesser harm. That is considered perfectly all right. Okay, moving on. Intoxication. Now, intoxication is not a defense if the intoxication has been taken voluntarily. Intoxication is nasha. Any substance which impairs your judgment or slows down your mental faculties called intoxication. Now, there can be many types of intoxication. Gile nase or sukhe nashe. N number of things can be there. Narcotics can be there. Alcohol can be there. N number of intoxications are there. But those intoxication which impair judgment or slows your response to stimuli. We are all stimulated by various stimuli, right? So if it slows your response to various stimuli or simply impairs judgment or obstructs your rational thinking, is considered as intoxication. So those intoxication, if a person voluntarily takes, अगर किसी ने जानबूझकर शराब पी है, तो and he commits any crime in that state of that intoxication, then there is full liability, in the sense that person will be held liable. But if the intoxication is involuntary intoxication means if the intoxication was administered to a person without his consent or without his knowledge, या तो आपको पता नहीं है और आपके खाने में, आपके ड्रिंक में किसी ने इंटॉक्सिकेशन मिला दिया, you got intoxicated without knowing that you have consumed intoxication, or it was given to you against your consent, in the sense that you have been pinned down and you have been injected with some intoxication, or sometimes it happened that doctors prescribe intoxication. Suppose I was in great pain because of an injury and doctors gave me morphine. That is also involuntary intoxication. So in those cases, if I commit an act while being intoxicated, my liability will not be there. So involuntary intoxication is a defense, is an exception of criminal liability. I was intoxicated, and intoxication should be of such an extent that it will impair, that the person will not be aware what he's doing. Intoxications के भी level होते हैं ना, थोड़ा intoxication, ज़्यादा intoxication. If I am intoxicated to such an extent that I am not knowing what I am doing, if I am unaware about the consequences of my action, then that is called that is heavy intoxication, and in that, if that intoxication is involuntary, means it have been administered to me without my knowledge or without my consent, then my liability will not be there. ठीक है, बट अगर वो इंटॉक्सिकेशन वॉलंटरी है, जानबूझकर मैंने शराब पी, अच्छा, if suppose somebody insists, like my friends tell me, oh, you'll have to drink, this is my birthday, bhai nahi hai kya, and all, that's not make the intoxication involuntary. For being involuntary, it has to be administered either completely without your knowledge or against your consent, means so much so that you have been physically overpowered and you have been forced to be intoxicated. Else, in every case, the intoxication will be considered voluntary. If somebody has urged you, somebody has insisted, somebody has blackmailed you into intoxication, that will be considered voluntary intoxication. I know some people, many a people start a lot of types of intoxications while then they are in college, and often that happens because of some peer pressure. There is a birthday party, your friend will say you have some intoxications. So my request to all the CLAT aspirants, because those who will you will reach and then national law universities, this has been a huge problem for all national law university, that the level of intoxication is very problematic. So that is why it is my request to all of you, stay away from any and all types of intoxicants. This will simply ruin your brain. This will ruin your health, and you'll be good for nothing. Intoxication is a poison. It might give you temporary enjoyment, but that is poisonous. Don't do that. Don't ever allow anyone to do that to you. Don't fall into the trap of peer pressure. Anybody who is giving you, any senior, junior batchmate who is giving you a textbook is your friend. Anybody who is giving you some weed or alcohol is your enemy. That person is not your friend. Moving on. So involuntary intoxication is exempted. Voluntary intoxications are not. And in the case of even voluntary intoxication, let's say the case of voluntary intoxication, if the person has committed a crime, now obviously that person is to be held liable. But sometimes because of intoxication, the mens rea is very difficult to prove. It is very difficult to prove that this person who was heavily drunk wanted to kill ABCD or wanted to do this. So that is why, in order to ensure that the person who gets drunk voluntarily and commits crime, he is held accountable. There is a presumption in law. Presumption is that if you are drunk, then whatever you do, we presume that you have knowledge of what you are doing. In the sense that knowledge will be presumed for every drunk person. Although the drunk person might not have any knowledge. In the morning, he might remember nothing. If you have taken drugs, or there are strong drugs as well, which will completely take away your capacity to think. In those cases, obviously, the person is not aware that what is happening around him. There are LSD and there are cocaine and methamphetamine. You'll have hallucinations and everything. So if a person is having those, he has taken those drugs and commits a crime, he is not allowed to say, "Ki, sir, I was not aware about at all that what I was doing." So there is no mens rea. So there is no mental element. So I should not be held liable. So that is why in Bharatiya Nyaya Sanhita, that is a presumption that if you are voluntarily intoxicated, then whatever you have done, we will presume that you did it knowingly, that there was knowledge on your part. That is something that the law will presume. That is why law is very strict on those who are simply they use intoxication as a just as a facade or as a shield to commit crime, as an excuse to commit a crime. No, if you are intoxicated, that's a huge problem. And if you commit anything, the law will presume that you knew what you are doing, even if you didn't. अगर आपको नहीं पता था आप इंटॉक्सिकेशन में आप क्या कर रहे हैं, तो लॉ मान कर चलेगा पूरा था कि आप क्या कर रहे हैं. समझ पा रहे हैं मेरी बात? हाउ डिफिकल्ट इट इज. So if a boy and a girl, they both got drunk and they had sexual relationship. Now the girl's consent is not valid because she was intoxicated, and boy was also intoxicated, but still he'll be held liable for rape because even though he didn't know what he was doing, still we'll presume that he knew that what he was doing. So boy will go to jail and the girl will be considered a rape victim. That is how the law works. So before you touch intoxication or you want to have fun with it, be very cautious. Okay. So this is my request to you all uh, as a fellow law professional. I'll just tell you, stay away from any types of intoxications. And you do not need to have fun. You do not need alcohol to have fun. The life has a lot of fun. And go to eat good food and it will be all be fine. Okay, moving on. Consent. See, consent is a very interesting defense in the sense that sometimes the harm does not become harm if it is has been consented. Those who are learning tort must have learned this defense as voluntary non-fit injuria. Means if you have consented to a particular harm, you cannot complain of it. So in criminal law, that particular defense is there, but in criminal law, the application of this defense is very limited in the sense that consent can save you from liability in several cases, but it may not save you in other cases. I'll give you an explanation of it. Let's say let's say what is the meaning of consent. Consent simply means that a person voluntarily takes a risk or is agrees to take a harm, and he has given that consent with no without two impediments. दो बाधाएं नहीं होनी चाहिए कंसेंट में. ये देखा ना, when consent is valid, so the consent should be free from two things. Number one is fear and second is misconception. Fear or misconception नहीं होना चाहिए in order to for a consent to be a valid consent. Somebody simply puts a gun in my on my head and says कि पैसा निकालो और मैंने उसको पैसा दे दिया, तो क्या मैंने उसको पैसा देने के लिए कंसेंट दिया? आंसर इज नो. A consent is not a valid consent if it is taken by fear to body, harm, property, reputation. If harm is threatened to body, property or reputation, that consent is not a valid consent. Second is misrepresentation. धोखा देकर consent लिया तो. There is a very famous case of R versus Williams. Now, in this case, what happens? There is a music teacher, and he has a female, there is a girl student, and he tells that music teacher tells the girl student that if you will have sexual relationship with me, the quality of your voice will improve. And that naive girl, she consented, and later on she came to know that it was all a lie. But the teacher said she consented, but her consent was not considered valid because her consent was based on a misconception. So if the consent is not based on fear or is not based on misconception, that consent is valid. Secondly, consent of a major is consent of a minor is no consent. 18 साल से ऊपर व्यक्ति कंसेंट दे रहा है तो कंसेंट मानेंगे, 18 साल से नीचे व्यक्ति कंसेंट दे रहा है तो कंसेंट नहीं मानेंगे. ठीक है, दिस मच इज क्लियर. देयर इज स्लाइट कॉन्टेक्स्ट टू दिट एज वेल. छोटी छोटी चीजों के लिए कंसेंट अलग तरीके से होता है, बट for a CLAT student, you simply understand that consent is consent when number one, it should be free from fear. It should not be. It should be free from misconception. And third, and the most important, the consent of a major is actually considered as a consent. ठीक है बच्चों, अभी तक यहाँ तक इसको कहते हैं लीगल कंसेंट. एंड कंसेंट ऑफ व्हाट? कंसेंट ऑफ एनी हार्म. एक डॉक्टर को हम कहते हैं कि डॉक्टर साहब मेरा दांत उखाड़ो, उसने दांत उखाड़ा, इट्स ऑल परफेक्टली ऑल राइट. बट एक डेंटिस्ट ने मुझको बिना मेरे कंसेंट के दांत निकाल लिया, that will be considered a crime, that will be considered grievous hurt, that will be considered criminal activity. So consent is what makes many an actions um, innocent, है ना, which will otherwise be a crime. अब कंसेंट के एग्जांपल बताइए बच्चों, शाबाश, सोचिए कंसेंट के एग्जांपल्स, n number of consent के एग्जांपल्स. Like suppose if you are live in a hostel, and obviously once you will be national university, you will be in a hostel. So if you are in a hostel, after 10 p.m., generally 10 p.m., 12 p.m., depends on the national university, they lock down the hostel. In the sense, nobody in or out without permission of the warden. Now, if a random person confines other person in a room, that is a crime. But you are confined into the hostel by the warden, that is not a crime. Why so? Because you consented. So if I consented to a particular act, I cannot consider it to be a crime. Okay, which will otherwise be a crime. Sexual relationship, if a woman consents, that is sexual relationship. If she does not consent, it's rape. So consent is very important in that sense. Then second situation is consent when it is not required. Acha, there are some actions you cannot do with consent of the other person as well, which is number one, you cannot do death with consent of someone. In India, euthanasia, active euthanasia is not allowed. Whatever the other person has consented, it must not involve death. Voluntarily causing death, you cannot cause death even with the consent of the person who is dying. Secondly, the consent will not take away the liability when it is an independent crime. कुछ बच्चों एक्टिविटीज ऐसी हैं जहां पे जो व्यक्ति हार्म सफर कर रहा है, वो अगर पर्सनल हार्म नहीं है तो उसका तो वो कंसेंट नहीं दे सकता. जो हार्म मेरा पर्सनली है, सिर्फ उसी के लिए मैं कंसेंट दे सकता हूं, विच इज नॉट माई पर्सनल हार्म. आई कैनॉट गिव कंसेंट. सपोज मेरा पड़ोसी है, आई कैनॉट से टू समवन, yes yes I give you consent, you beat B. Well, harm is supposed to be suffered by B, I cannot give consent. But if I am a guardian or a parent, I can give that consent. Otherwise, suppose a bank manager gives consent to a robber to rob a bank or to take all the money that is there in the bank. Whether the bank robber will be liable or not liable. The answer is the bank robber will be liable, even though bank manager gave consent, because bank manager was not in a position to give consent. वो पैसा बैंक मैनेजर के पिताजी का नहीं था, वो पैसा पब्लिक का था. बैंक मैनेजर कंसेंट से काम नहीं चलेगा. तो कंसेंट केवल पर्सनल हार्म के लिए दे सकते हैं, और वो भी तब नहीं दे सकते व्हेन द act that is being done is an independent offense. Independent offense means as a separate offense. Like I'll give you example. किडनी, आपने सुना ना, किडनी बेच दी. दैट जोक इज ऑफन यूज दैट कि एक व्यक्ति ने आईफोन खरीदा तो किडनी बेच दी होगी आईफोन खरीदने के लिए. द क्वेश्चन इज वेदर यू कैन एक्चुअली सेल योर किडनीज. द आंसर इज नो. है ना, वो बाबू राव को कहता है ना, एक आंख बेच दूंगा, एक फिर एक आंख और आंख बेच दूंगा, एक किडनी बेच दूंगा एंड ऑल. तो देव मानुष समझ रहे थे उसको बाबू भैया. So whether you can actually do that, answer is no. There is Transplantation of Human Organs and Tissues Act, THOTA, 1994 legislation, which prohibits that nobody will sell or purchase the kidney or any organ of the human body. Even selling blood is prohibited. So suppose somebody has agreed, given his consent to someone कि आप मेरी किडनी निकाल लो और आप रख लो, मुझे 10 लाख रुपए दे देना. Now, whether this person's consent will absolve the liability of the person who has taken the kidney, answer is no. क्योंकि ये एक इंडिपेंडेंट ऑफेंस है. किसी की बॉडी करके किडनी निकाली आपने और उसके बदले पैसे का लेन देन किया, दैट इज एन ऑफेंस अंडर ह्यूमन ट्रांसप्लांटेशन ऑफ ह्यूमन ऑर्गन एक्ट. दैट इज एन इंडिपेंडेंट ऑफेंस. सिमिलरली मिसकैरेज. If a woman consents that I want to miscarry a child which is fairly advanced stage of pregnancy mein, if she has an advanced pregnancy, the doctor, if you will go to a doctor will not miscarry that child. विदाउट द परमिशन ऑफ द कोर्ट. A healthy fetus को abort नहीं करेंगे. And if the doctor actually aborts that healthy fetus, in that case it will be a crime. Even though the woman consented, even if the mother consented, it will be considered a crime. So sometimes consent will not absolve you from liability because of two reasons. Number one, the consent was not yours to give, or number two, if it's an independent crime. Okay, when the consent is not required, see, if a person does an act for the benefit of other person, and that does not involve grievous hurt or something like that, in that case even the act done without consent for the benefit of other is considered to be exempted. कई बार आप किसी के बेनिफिट के लिए, सपोज कोई व्यक्ति बेहोश है, आप उसको उसके कंसेंट के बिना टच करते हैं, उठाते हैं, उसको हॉस्पिटल लेकर के जाते हैं, तो obviously that is not a crime. Why so? Because you did that for the benefit of that person. अदरवाइज आप किसी रैंडम व्यक्ति को घर पे सो रहा है, उसको आप उठाइए और कहीं और लेके चले जाइए, दैट विल बी abduction, kidnapping. But it will not be a kidnapping or abduction if you're concerned for that person's health. आप उसके हेल्थ से कंसर्न है, कोई बेहोश पड़ा है, आप उसको उठाकर डॉक्टर के पास ले गए, दैट इज नॉट अ क्राइम. इन दैट केसेस कंसेंट इज नॉट रिक्वायर्ड. Okay, so consent is not required when you have done that act for the benefit of that person. If you have caused harm to another person, but if it's for the benefit of that person, in that case the consent is not considered. The consent is not required, and the harm done will be not be considered a crime. बस इसमें ये समझना है बच्चों कि कंसेंट के बिना अगर आप करते हो तो एक्चुअली उसमें कोई ग्रेव हार्म नहीं होना चाहिए सामने वाले को. In that case, a grave harm has happened. In that case, liability might be there. But if you have done something for the benefit of that person, perfectly all right. Especially in the case when the person was incapable of giving consent, if you have done something for the benefit of that person, perfectly all right. So, if the consent is there is no liability except in the case of death. Secondly, the consent is not required to be given when the act done is for the benefit of other person. And third, the consent will not absolve a person from liability if the consent given was not for that person to give, means the person was not entitled to give that consent, or the harm that was caused was an independent harm, means that it was a harm that is an independent crime. Okay, so this is called consent. Then we have compulsion. Compulsion means simply if you have been threatened by instant death to do something, then what you're supposed to do? You will do that thing immediately. Obviously, without a doubt. Compulsion means if you have been threatened with instant death, then whatever you do is exempted. Suppose on gunpoint you have been asked to hand over keys. What you will do? You will hand over the keys. Whatever is expected of you, you will do that if you have been compelled by by the threat of instant death. Like I'll give you an example, very simple. Suppose you are a bank manager, guard or employee, and somebody comes and points a gun towards you and say, "Open the vault." What you will do? You will open the vault. Sometimes it is not good to be a hero. Simple. आत्मानं सत्यम रक्षेत. Always protect yourself first. So there are all those actions which you have done on with the threat of death. In that cases, you are exempted from the criminal liability. There's a small exception that you must not have put yourself in that position where that threat will be given to you. Like you must not join a gang of robbers or Naxalites. Obviously, if you become a Naxalite, they will ask you to commit crimes. In that case, you cannot say no, 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 no. See, I have been compelled to commit a crime. Who asked you to join Naxalites? Obviously, they will not feed you sitting. They'll ask you to commit crimes. If you have are you have joined a gang of robbers by yourself, those robbers will ask you to commit robbery. And in that case, if you have committed robbery, you cannot say, no, no, I was threatened with instant death, so that's why I committed robbery. No, because you yourself joined the gang of robbers. In that case, it will not be considered compulsion. Then there are two things which are not justified by compulsion, even though compulsion might be there, but that is not justified. Even if you are threatened by instant death, there are two things that you should not do, and that will not be exempted. Number one, obviously, is death of someone else. And yeah, meaning thereby, you cannot kill someone else for protecting your life. Logic being very simple, your own life is not precious than someone else's life. आपकी अपने जान की कीमत ज्यादा नहीं है दूसरे की जान से. So obviously, uh, your action is not justified if you have killed someone voluntarily to save your own life. Okay, so even if you are threatened with death, somebody puts a gun on your head and says you kill that person, you don't do it. If you do it, you will be held liable because your death was no, your life is not cause more important than anyone else's life. So somebody pulls a gun on your head and you asks you to kill someone, you ask them to pull the trigger. Second is offenses against the state, treason. Offenses against state. You do not wage war against India even if you are threatened with death. मतलब देश के साथ गद्दारी नहीं करेंगे अगर आपके ऊपर डेथ का भी खतरा हो तो. Because the interest of the nation is paramount, it's supreme. So even if suppose you have some military secrets and somebody threatens you with death and says that either you give me that confidential information or I will kill you. So what you I will ask them? You'll ask them, go ahead, you kill me, but I will not betray the nation. So do not do something that uh, is considered espionage or treason. Offenses against the state are not justified even by the threat of instant death. Somebody says, yeah, I'll kill you if you'll not betray your nation. You just tell them, go ahead. You know, there is thousands of life are nothing in front of the interest of Bharat Mata. So in protection of Bharat Mata, nobody should should give it a second thought. There should not be two thoughts in your mind. You should always be yes, my life for the betterment of the nation. You know? Okay, that is something that is very clear. So compulsion will exempt you from liability if only it is not for the purpose of causing death of another person or for offenses against the state. Okay, that much is clear. Compulsion is clear. Okay, let's talk about the last portion. It is triviality. Triviality is de minimis non curat lex. Law does not take care of trifles. Law does not concern itself with trivial acts. Now, what is meant by trivial acts? Trivial acts simply means those actions which are of extremely slight harm and no person of ordinary sense and temper will complain of it. है ना? Yes, I'll give you an example. Let's suppose you have a notebook. I have a notebook. Somebody comes and tears a page from that notebook and goes away. One page that person took without my consent. Now the question is whether he has committed an offense. An answer can be yes. If I if I'll give a strict interpretation, or if I look into the very action of that person, that is a crime. Somebody took 1 rupee from me, that is theft. Somebody tore one page of my copy, that is theft. Somebody borrowed my pen for 5 minutes, that is theft. But the question is whether you want that person to be jailed for 3 years for taking your pen for 5 minutes or tearing your one page of your notebook. The answer is no. Because the harm that has been caused is so slight that ordinary sense and temper का व्यक्ति को उससे कोई दिक्कत नहीं हो. समझ पा रहे हैं आप मेरी बात? sometimes the harm is very trivial. Like suppose I entered your house, a dog एक कुत्ते ने मुझे पीछे भगा लिया, मैं आपके घर में घुस गया और फिर आपको क्षमा बोल करके बाहर निकलने लगा, आपने मेरे खिलाफ कंप्लेंट कर दी पुलिस में कि भाई ये सी द केसेस व्हिच यूज्ड टू कम. If you want to know what is trivial, you can watch a there is a daily soap, very funny daily soap known as FIR. FIR used to be a show in which all the trivial cases used to come to the police station. So somebody comes to you कि सर होली में रंग लगा दिया मुझको. Obviously those who are eccentric, सनकी लोग हैं, those who have some temper issues, anger issues, they will be outraged by that particular action. कि अरे रंग कैसे लगा दिया होली में, या सपोज somebody use some harsh word against someone. अब सपोज बॉयज हॉस्टल में कोई व्यक्ति हैं और इन द group among friends, male friends, the language that people use is bit intemperate. थोड़ा सा लैंग्वेज थोड़ी सी कड़ी या सख्त, और थोड़ी कई बार it is inappropriate language that is used. And generally people consider that okay, fine, no problem. है ना? But if a person who is so eccentric, oh भाई साहब ऐसे कैसे बोल दिया, no. So if the harm caused is very slight, so slight that an ordinary person of ordinary temper will not take notice of it, he'll simply say no problem, sorry, thank you. This much will happen. In that case, that is considered as triviality. So if the offense is very trivial, सर 10 रुपए ले लिए, 5 रुपए का नुकसान हो गया, सर जो है दाग लग गया शर्ट पे, कुछ फालतू सी चीजें हैं जो है ना, कह दी कि सर मुझको कुत्ता कह दिया, all those things are considered trivial because that will waste the time of the court, which can otherwise be utilized in a more productive way. So if that such is the situation, in that case, those actions are considered as trivial. So if the actions are trivial, in that case, the liability is not there. But there is a specific type of instances where even the smallest and smallest actions are not considered trivial. And there are two things in respect of that. Number one is some socio-economic offenses, corruption. 10 रुपए का करप्शन भी उतना ही खतरनाक है जितना 100 रुपए का करप्शन, जितना 1000 रुपए का करप्शन. तो अगर आपसे रेलवे के काउंटर में आपने 100 रुपए दिए, 95 का टिकट हुआ, 5 रुपए नहीं लौटाए, दिस इज ऑल्सो अ करप्शन, करप्ट एक्शन. एंड करप्शन में देयर इज नथिंग ट्रिवियल. करप्शन में आपसे कोर्ट में, although that it happens that you will go in courts and somebody, munshi peshkar will ask you 100, 500, and rupees, 10 rupees, 50 rupees. In every place you'll have to give some money to the people who are involved, and that is not considered trivial. Even if somebody takes 1 rupees, 5, 10 rupees bribe, that is not considered trivial. You can go ahead and complain about it. Secondly, there is nothing trivial when it comes to dignity of women. महिलाओं से छेड़खानी में कुछ triviality नहीं. Means even if a person stares at woman for a significant portion so as to make her uncomfortable, it is not trivial. That person cannot say कि सर हम तो घूर ही रहे थे, तो हम देखकर गाना ही तो गा रहे थे, हमने कहा उनको टच किया. No, that is not trivial. That is considered a crime, and that is a serious crime. Nothing is trivial when it comes to dignity of woman, outraging the modesty of a woman. If somebody touches a woman inappropriately, that is considered a criminal act. Although that might not have caused that much harm, there's nothing trivial. The harm is not slight when it comes to sexual abuse of women. In all other respect, it can be slight harm, like you just simply give a pat on the back of your friend. फ्रेंड को टपली मार दी आपने, तो वो स्लाइट हार्म है, बिल्कुल ठीक है, नो प्रॉब्लम. Even that friend is a woman, girl, you can give a tapli, that is fine, because the nature of harm is not sexual. But if there is a sexual harassment angle is involved, if the harm that has been caused is to the modesty of woman, in that case nothing is trivial. A person will be punished for even smallest of the infraction. If you simply sing a lewd song while seeing a woman, that is considered a crime, although you might not have even touched that woman. है ना? Even if you stalk that woman, that is not considered trivial. Online stalking, if you are doing, that is also not trivial. On every picture you go, a nice pic deer, and that is also cannot consider trivial. Jokes apart, triviality is a very important defense, but we have to consider what acts are trivial and what acts are not trivial. Okay, so this much we have discussed already. Next is coming is private defense. Again, a very, very interesting topic. So I'll see you all in the next class. So thank you so much. I hope you learned something. Obviously, if you want to get in touch with me, please mail me at animesh@mpdnlu. I'll be happy to help. If you have any doubt from what we have discussed, please go ahead and mail it to me, and I'll respond by making a video, or I will respond personally as well. So thank you so much. I'll see you all in the next class. Thank you for being listeners.